Very eminent set of speakers. Dr. Sashi Tharoor, Member of Parliament and former Minister of State for External Affairs, is an author and India's official candidate for the post of United Nations Secretary General in 2006. He says he is stuck in Parliament, so we are expecting him later in the day as the debate progresses. Mr. Fali Nariman, distinguished constitutional lawyer, senior Supreme Court advocate since 1971, and Padma Vibhushan awardee. In 1975, he resigned from the post of Additional Solicitor General to protest the emergency. Mr. Nariman's complaint on behalf of his client of the Sahara India Group is the immediate provocation for the Supreme Court wanting to frame guidelines, but Mr. Nariman has argued against any form of censorship. Ms. Amrinal Pandey, chairperson of the Prasar Bharati Board, and until recently editor of Hindustan, her latest book is The Other Country, which brings out the fault lines between the small town and the metropolis. Dr. Sanjay Baru, currently Director of Geoeconomics and Strategy at the International Institute of Strategic Studies. He was media advisor to the Prime Minister for 4 years, and for 8 years he has been editor of Business Standard and the Financial Express. Mr. Vinod Meheta is now advisor to Outlook magazine. In February, he relinquished charge as editor-in-chief of the magazine, which he founded 17 years ago. The last issue of the Outlook magazine has a cover story on the very issue that we are debating today. Simon Denyer, India Bureau Chief of Washington Post. Before his current assignment, he was Washington Bureau Chief of Reuters, and previous to that, Reuters Bureau Chief for India, Nepal, and Bhutan. He is also president of the Foreign Correspondents Club. And our very own Paranjoy Guhathakurta is going to moderate the discussion. He is president of the Foundation for Media Professionals. He is also author of a book on coalition politics and another on media ethics. He was co-author of the report on paid news for the Press Council of India. So, Mr. Tharoor, Mr. Nariman, Mr. Mehta, Simon, Sanjay Baru, and Paranjoy, please come to the dais.
The subject that we are discussing, it's often asked why? Why now? We ourselves, we who've been journalists here, we ourselves have been somewhat puzzled at a series of circumstances that seem to have combined all of a sudden, come together. We've had a court saying journalists should not be allowed to report troop movements. Before that happened, there was a front page article in the Indian Express where a number of its correspondents and writers, including its editor, wrote about what seemed to many a suggestion that there was something amiss about the way in which troop movements were taking place. When Mr. Vinod Meheta on the right commented about that in a magazine, Open magazine, in an interview, he's been slapped with a notice with damages of 500 crore rupees. That's a record in India at present. So Mr. Vinod Meheta has been, and the publisher and editor of Open magazine, have been accused of criminal defamation. We've had a private member's bill being introduced by a member of parliament who is known to be close to the youngest general secretary of the Congress party, Ms. Meenakshi Natarajan. But soon after she introduces that private member's bill, the Congress party promptly says we have nothing to do with it. But that bill seeks the formation of a regulatory body to regulate, stroke, control the profession. We've had the chairman of the Press Council of India, Justice Markandeya Kaju, who draws a distinction between control and regulate. We had asked him to come for this panel discussion, but he declined. He declined to come. We asked a number of other people to come, but for various reasons they chose not to come, reasons best known to them. But we find that there seems to be a whole set of circumstances which have come together. There's one other important thing that's happened, and Mr. Nariman will surely talk about this. We have the Supreme Court of India, a bench, a 5-judge bench, a constitutional bench of the highest court of this country, currently engaged in trying to work out a set of norms about how journalists should report court proceedings in a manner in which it does not prejudice the interests of accused persons. The question that we are asking over and over again, why now? Are the laws of the land, which are applicable to everybody, including journalists, are they inadequate? Do we need a separate set of guidelines for journalists? What kind of guidelines? We already have self-regulatory bodies like the News Broadcasters Association. We have the Press Council of India, which is a quasi-judicial authority set up by an Act of Parliament. It has a set of guidelines for reporters and journalists, but it has no powers to enforce these guidelines. It has no punitive powers. The Press Council has no powers to punish anybody. So this is the current, this is the backdrop that is currently prevailing, which we are going to discuss a set of issues about if self-regulation is inadequate, why is it inadequate? Do journalists need to be treated separately? We call ourselves the proverbial fourth estate. Freedom of expression, Article 19(1)(a) of the Constitution of India says that's a fundamental right of every citizen, but we also have Article 19(2), which puts out what are called reasonable restrictions. The whole issue is who decides what is reasonable? How are these to be enforced? The issues relating to public order, friendly relations with other countries. There's the issue of blasphemy, criminal defamation, invasion of privacy. There are a host of all issues that all tend to get interlinked and mingle into this bigger issue. What we're going to do today, we're going to ask each of the speakers, and I'm expecting Dr. Sashi Tharoor to join us soon. He's in Parliament and he's expecting to come join us very soon. We're going to ask each of the speakers to speak for approximately 15 minutes. And after that, we'll have an open discussion. All of you here should feel free to ask any questions you wish to. So I'm going to start with Mr. Vinod Meheta.
Friends, we are here to discuss media under siege. It's not a phrase that in my 35 years of editorship in India that I have had pleasure of speaking on before. I don't think this phrase has been used, media under siege. We've had problems that I think 87 Rajiv Gandhi tried to promote a bill of defamation, etc. But I can't remember the last time there was a discussion of media under siege. Siege would suggest that we are being attacked from many quarters. And as has been outlined by the earlier speaker, that is true. Courts are after us, the government of course is after us, private members' bill are there. In the Lokpal, if I remember when that discussion was going on, there was a suggestion that the media, and the print media in particular, should be brought under the jurisdiction of the Lokpal. And the government periodically announces that while they are committed to the freedom of the press, there is some need for external regulation. So all these forces are out to attack us. And what you and I and the profession has to decide is whether this constitutes some sort of introspection on our part about the way we function. Or is this something we say, well, it'll go away, these chaps are always out to get the press, they'll go away. And it'll be business as usual. So we have to decide whether we are in denial of the fact that the media is under siege. If we are in denial, then we might as well pack up and go, all of us here, because if there's no media under siege, then why are we having this discussion? One thing which I found missing is that the lack of support from the only constituency the media has, which is the public, which is the viewing public and the reading public. I hear a sort of deafening silence on their part to the fact that the media is saying, listen, freedom is in danger, freedom of the press is in danger, and therefore please stop these people who are trying for external regulation. I don't hear too much protest from the public. And the inference that one can draw from that is that the great and very high public credibility that we had is being eroded or has been substantially eroded. Now when you talk like this, then people say, well, what about the CWG scam? What about the 2G scam? Didn't the media expose that? And so you're supposed to shut up after that and say nothing is wrong. We don't have a fora where somebody who has a complaint against the press can go to. Now this is the other thing that the press does, that the press is made up of people who are infallible, who never make a mistake. They are something like gods. They never make mistakes. And if they do make mistakes, they correct it. It's a mistake could be that Mamata Banerjee has said something, or you claim she said something, then she said she hasn't said that thing, and then you correct. That's sort of mistake. But what happens when there are really very serious mistakes and serious allegations? What do you do with that? And I'm not just talking about the government, I'm talking about the man, the so-called Aam Aadmi, who has some kind of grievance against. Where does he go? There's no place for him to go, no place for him to take his complaint. So I have been arguing for some time now that there is a need for us in the press to look at the way that we work ourselves, because we ask everybody else to be accountable. What about our accountability as the media? Are we unaccountable? Do we never make any mistakes? And if we make some mistake, then what happens is that the mistake is made on page 1 and the denial comes on page 17 at the bottom. So what is to be, has that chap got justice with that denial? So we have to decide whether there is any need for us to examine the way we work, or are we going to say any call for the examination of or a scrutiny of the way the media works is to be avoided, because that's another way of trying to regulate the media. I have argued that there is a need to convince the skeptics in our own profession. I think this is an intra-professional dialogue. We don't have to worry about the politicians. We have to worry about our own profession, which I think, no need to hide that, is vertically divided, absolutely vertically divided on the need for any introspection. They feel that everything is going fine, why do we do this? And if we allow this introspection, it will be a way of taking away our freedom. So, business as usual. I am arguing that if we continue to work the way we do, we will be giving an opportunity for external regulation. We will make it easier for people to impose regulation on us. And therefore, in our own self-interest, it is essential that we create some fora, the profession creates some fora, where there can be quick 30 days, I think. There is in Britain where the great Mr. Murdoch has been demolished by a great story there. The greatest newspaper man demolished by the smallest newspaper in Britain. And so he is probably going to jail. Or some of his editors are in jail. He will probably end up in jail. They have a thing called a Press Complaints Commission. Whatever you want to call it, that's all right. That is funded by the media and chaired by a judge, I think. But it's funded by the media and is made up of the media, of the print media. And they have to, their mandate is that within 30 days, they have to, if somebody goes with a complaint, they have to tell you whether you are justified or not. Now, when I've suggested this, I don't think there have been many takers, simply because they think that this is another way to erode the freedom of the press. I just end by saying that this is no reason for us to panic or anything, but there is reason for us, and very urgent reason, that we look at the way we work. Because you see, when it comes to if some minister makes the mistake, some kind of error, everybody jumps and says, let there be an inquiry. Prima facie, Chidambaram has God knows how many of these demands. Let there be a prima facie inquiry, and while that inquiry is going on, Mr. Chidambaram should step down. We are very quick on that. But when somebody says that so and so story in a particular paper was wrong or was overdone, whatever it was, or was correct finally you go with a complaint and the body says, no, that's perfectly all right, the story is all right. So you are validated by your peers. So my contention, and I'm in a minority, I think, I'm not in a majority, I'm in a minority, that we need not external self-regulation. I'd say don't even call it regulation. If you have some problem with the word regulation, don't even call it regulation. Some professional press fora where we can debate professional issues, where we can look at complaints and we can say, no, this complaint is bogus, this paper is absolutely right. But this vacuum that we have at the moment, we are torn between Justice Karju and the courts, between the devil and the deep blue sea. So there's no other place. And therefore, the issue before us is, are we in denial? Do we believe that media is under siege? Or don't? If we believe the media is under siege, then it's incumbent upon us to do something about it. Thank you very much.
May I request Mr. Fali Nariman to provide his perspective as a legal person, as an eminent jurist?
I prefer to speak standing. It's an occupational thing. Good friend Vinod is the real sacrificial goat of the day. As Paranjoy told you, he's the man on the cross with 500 crores on his head, but he does not look one bit diminished. Starting with the topic itself, do you really believe that today the media is under siege? I have a slightly different take on this. I would suggest to you that the freedom that the press and the electronic media enjoy in this country at this time are not enjoyed anywhere. Not anywhere except perhaps in the United States. Certainly not in any country in the South Asian region. This fact was dramatically brought home to me a few years ago when my wife and I attended the Commonwealth Law Conference in Malaysia. In the presence of the country's Prime Minister, a delegate who was a judge of Malaysia's Court of Appeal, since retired, said to a crowded hall of over 500 delegates in Kuala Lumpur, in a very loud voice, "Our written constitution guarantees freedom of speech." And then, after a long pause, he continued in a softer voice, "But no freedom after speech." These were not flippant words, ladies and gentlemen, but words wisely and deliberately chosen. Ponder over them. Freedom after speech, that in essence is what freedom of speech is all about. Within 6 months of the promulgation of our Constitution, 1950 Constitution, India's first Supreme Court laid down the parameters of Article 19(1)A, which we so glibly speak about. When Romesh Thapar's weekly crossroads was banned entry by the state government of Madras on the ground that it was apprehended that it would disturb the security of the state. An otherwise permissible restriction under 19.2, the order, when challenged, was quashed. The court said that the omission of the word sedition from the draft Article 19.1 by the framers of the Constitution showed that the criticism of government exciting disaffection or bad feelings towards it was not to be regarded as a justifying ground for restricting the freedom of expression and of the press unless it was such as to have the tendency to overthrow the state. A freedom of such amplitude, the court said, does involve risks of abuse. But in words borrowed from James Madison, the leading spirit in the preparation of the First Amendment of the United States Constitution, our court said, and I quote, "It is better to leave a few of its noxious branches to their luxuriant growth than by pruning them away to injure the vigor of those yielding proper fruit." In the companion case, this is just 6 months after our constitution came into force, the companion case known as Bridgebushen's case, the same bench of 5 judges quashed and set aside an order made by the Chief Commissioner of Delhi in regard to an English weekly, the Organizer, on the ground that the East Punjab Safety Act of 1949, imposing pre-censorship on the journal, was definitely an unreasonable restriction of the liberty of the press, which the court said is an essential part of the right to freedom of speech and expression as declared in 1918. The decision in these 2 cases have held the field for the last 62 years, and I hope that what the court said in them will never be departed from. Then, India's first elected parliament from the year 1952 gave additional protection to you editors and journalists by enacting the Parliamentary Proceedings Protection of Publication Act 1956. That act said, no person, which of course primarily meant no journalist, shall be liable to any proceedings, civil or criminal, in any court, in respect of the publication in a newspaper of a substantially true report of any proceedings of either House of Parliament, unless the publication was proved to have been made with malice. When a later Parliament met, soon after the imposition of the June 75 emergency, almost every member present complimented, most disgracefully I believe, the Speaker of the Lok Sabha and the Chairman of the Rajya Sabha as to how smoothly the proceedings were going on, without once mentioning that this was because there were no members of the opposition present. They were all under preventive detention. Unfortunately, this event was reported in the press and it led to the repeal of the 1956 Act during the internal emergency. The freedom to report proceedings in Parliament, even a substantially true report of proceedings in Parliament, was taken away. Only one person stood up and stood out. Then, he was Mr. Chandrasekhar, later Prime Minister, though only for a brief period. I wish that he should be remembered today. It was he who loudly and bitterly complained about the internal emergency. He was the angry young Turk, but like young Turks of his time, he grew old and feeble and has passed on. But he was a man of his time, one to be reckoned with and respected. After the internal emergency ended and came the March election of 1977, the repealed Parliamentary Proceedings Act was re-enacted by the then freshly elected Parliament. So please remember, you editors, you journalists of the print and electronic media, you are the most extraordinarily privileged bunch of people, considered absolutely indispensable under our Constitution and our laws. Not because of yourselves, for God's sake, but because of those whom you claim to represent. Privilege carries with it responsibility. The responsibility not to misreport, not to make mistakes, not to be bought off by the rich and powerful, not to crawl before those in authority when you are asked to bend. Of course, we all make mistakes. Doctors make mistakes. They call them dead bodies. Lawyers make mistakes. They call them mistakes inmates when clients go to jail because of mistakes of their lawyer at the trial. Diplomats pass off their mistakes and call them wars. But in journalism, the mistakes of journalists, often innocent, sometimes, yes, I repeat, sometimes venal and deliberate, are spread out for all to see. There is simply no protection against misreporting except the internal setting up of standards and their supervision by some independent authority. Because a misreport or wrong report, do remember, sticks in the public mind even after it is corrected. It sticks in the minds of those judges who sit in Tughlaq Road. Hence today's debate. Hence the importance not only of a free press and a media, which we mouth every day, but of a fair press or media. Many years ago, the London Times, in a grand editorial, stressed the importance of public faith in the media as being more fundamental than any constitutional guarantee. This is how it read. Those who wish to maintain the freedom of a nation must stand behind the editorial freedom of the press, even though they know it will sometimes be abused and be often wrong in its judgments. Freedom of the press is cherished, not just tolerated but cherished in all free societies, not for the benefit of the press as an institution, not because journalists should not be regulated, as the title of today's topic suggests. On the contrary, all of us need to be regulated. It is time you speedily regulate yourselves, or be sure, as night follows day, you will be regulated by law, and even absent law, by those forbidding judges who sit on Tilak Marg. Freedom of the media is a cherished freedom, not for the journalists, but for the greater public. For many years, Sulzberger was president of the New York Times from 1933 to 1957. No one has beaten that record. And it was he who said, the freedom is not the journalist's freedom to write or the publisher's freedom to print. It is rather the citizen's right to know. And it was he who defined the correct role of journalists in a jovial quip. This is what he said. We journalists must tell the public which way the cat is jumping, not why. Which way the cat is jumping, not why. The public will take care of that. It was Jeremy Bentham, the theoretical jurist, who characterized the common law as dog law. When your dog does anything you want to break him off, he wrote in 1832, you wait till he does it and then you beat him. That is the way you make laws for your dog. And this is the way judges make laws for you and me. This is what Jeremy Bentham wrote way back in the 19th century, and it is true today. The law of contempt of court in Anglo-Saxon jurisprudence has been for long. In some countries like ours, it still is dog law. It does not define, often even when embodied in a statute, what precisely will be regarded as contempt of court and what will not. It gives little guidance to the editor or the broadcaster. It serves only as a standing threat to freedom of expression. It leaves too much to the discretion of the particular judge or judges investigating into reports, in italics, by the press. There are no clear answers given even by judges in contempt of court cases, which makes us all reflect a bit. I suggest we use the opportunity afforded by this public debate today to lay down norms, not to wait for Parliament or judges to lay down norms for us. We can only do this if you journalists, with senior editors taking the lead, act as a body, get down to business, formulate definite principles, certain workaday rules, which would help preserve the delicate balance, and it is a delicate balance, between the free press on the one hand and fair trial and fair hearing in court, which is worrying the judges on the other. What are known as the Nebraska Bar Press Guidelines. They are the only guidelines that I know that have been approved by a country's highest court, the US Supreme Court, way back in 1976. They are appended as an annexure to one of the supporting judgments in the Nebraska case, are instructive only as an example of what can be done by a cooperative effort. More recently, there are a set of guidelines which have been formulated by judges sitting along with journalists. And there is an excellent foreword written to this compendium, published in the United Kingdom, which has a foreword written by the country's Lord Chief Justice, man by the name of Lord Judge. His name is Judge, he got Judge. Now, that only shows that cooperative efforts do yield fruit. You don't need laws, you don't need dog law, you don't need a big stick to beat the journalist or the editor. It can be done cooperatively, and all of you must get together and try. There is a perception, please do remember, in the public mind, may not be in your mind, that many of you, or some of you, are unfair, that you can be purchased, that you can do things which are wrong. Absolutely. Look in, introspect a bit, and then get together. And it is the senior journalists, the senior editors who have to take the lead. Otherwise, I am afraid, you will be regulated despite all you say, despite today's debate, and the public will applaud. That's the necessary consequence. Do it now. Get together. Form an association. Don't think that you are impregnable, that no one can touch you. I'm afraid we the people, that's how our constitution begins. They can touch you, and they will, in one form or another, whether legislators or judges. But to say that the court reporter misreports is also not always correct. He or she may not, often does not, understand the mumbo jumbo of judicial reasoning. I remember in a lecture delivered way back in 1960 by Sir Ninian Stephen, a very distinguished Chief Justice of Australia. He later became the Governor General of Australia. It was suggested by him that when a court issues an important judgment, it should at the same time issue a press release, short press release, which would explain in layman's language what the issues were, who won, who lost, and why. In fact, the European Court of Human Rights at Strasbourg, the European Court of Justice at Luxembourg, from time to time issue such press releases to assist non-specialists to understand and then report what judges have decided. This greatly helps to alleviate misunderstandings, which are often the cause of friction between media and the court. Not only does the media have an obligation to the public, which it serves, of disseminating all such information and ideas freely and fearlessly, but the public has also the right to receive that. If it were otherwise, the media would be unable to play its vital role of watchdog. The media is also the only means by which politicians and the public, and this is important, can verify whether judges, who are generally insular and secretive as a class, are discharging their onerous duties in a manner that is in conformity with the task constitutionally and statutorily entrusted to them. A favorite quote of a favorite and honored Chief Justice of India, Justice Venkatachala, was one which US Supreme Court Justice Brandeis first introduced. Brandeis said in a judgment, "Sunlight is the best disinfectant and electric light is the most efficient policeman." The man or woman with the torch then is you, the journalist. But one thing you must remember, must be remembered also by judges, by lawyers, by all of us. Tyranny fears newspapers, not the rest of the media. There I agree with my friend Vinod. Not even television, only newspapers. Tyrants live in fear of them and suppress them when they can. They don't fear politicians or judges, only newspapers. that infamous martial law decree of General Jaruzelski issued in Poland in December 1981, when a wide range of civil liberties were banned, is a case in point. It is worth quoting. This is how it read. Just listen. This is Jaruzelski speaking on the radio in Poland. Good afternoon, comrades. I have the responsibility and honor of providing to you the rules which have been constructed by the People's Party to ensure that all our citizens enjoy the restoration of order and truth. First rule, distribution of any publication, the use of printing equipment of any kind will require prior government approval. Second, mail, telephone services and other telecommunications are all suspended. They will resume as soon as the censorship directorate is fully staffed. Third, one radio station and one television station will be operating. Mark you, one radio station and one television station will be operating, both from the capital. I will be the commentator. Finally, you may ask what you should do to obtain governmental approval necessary for any printing. We are working on it. We'll let you know. Meanwhile, comrades, please understand, no newspapers. That's how the message ended. That was the thrust of the martial law decree in Poland, issued in December 81, 30 years ago. And it had its effect. It was only the endurance and courage of the leaders of Solidarity and other great nationalists that helped to overthrow the Jaruzelski government, but not without a fight, not without bloodshed. Jaruzelski's decree must never happen again anywhere. It can never happen in a free society where those in governance respect the rule of law. But what about abuses of information, circulation of false information, and character assassination by the press, of which all of you are accused from time to time? Are the blessings of a free press or media really worthwhile? There are two answers. The first given in July 1950 by our own Supreme Court in the Crosswords case, which I already quoted. But the second answer, the more earthy answer, comes from a politician, a wily one, a fellow called Mario Cuomo, who was former governor of New York. He was addressing a prestigious body, the New York Press Club, some years ago. Soon after, the New York Times, in an editorial, accused him, the governor, of political patronage through his law firm run by his son. Cuomo spoke about press freedom, and this is what he said when speaking about the First Amendment of the US Constitution. And I quote, "The founding fathers knew precisely what they were dealing with. They had a press, and the press of their time was not only guilty of bad taste and inaccuracy, it was partisan, reckless, sometimes vicious. Indeed, the founding fathers were themselves often at the point end of the press sword. In view of that experience, they might have written amendments that never mentioned freedom of the press, or they might have tried to protect against an imperfect press like the one they dealt with conditions, qualifications, requirements, penalties. They knew the dangers. They knew that broad freedoms would be inevitably accompanied by some abuse and even harm to innocent people. Knowing all the odds, they chose to gamble on liberty. And the gamble has made us all rich and happy. Overall, the press has been a force for good, educating our people, guarding our freedom, watching our government, challenging it, goading it, revealing it, forcing it into the open. I believe we must, as Governor Cuomo said, gamble on liberty. There's simply no other way. Thank you.
There was a time when media felt under siege, when hundreds of journalists marched down Rajpath. I think Vinod Meheta was also there, when the entire media actually came out in public concerned about a threat to freedom of the press. So therefore, I am not particularly worried that the media is under siege from outside. What I am worried, and which is why I endorse what Mr. Nariman has said, is that the media as a profession is under siege from within. And I have said this as an editor on many occasions. I have said this in every journalism college I have had the opportunity to talk to, that the professionalism of this profession has come under increasing public scrutiny. What is it that you learn as a student of journalism is the limit that you cannot cross before you cease to be a journalist. As a profession, we don't have a definition. When do you lose the license to be a journalist? Never. Wrong story after wrong story. You continue to rise up the ladder, have done the right things. You become an editor, you become a CEO editor, you become proprietor. So our profession is under siege from within. And we don't focus on it. I agree with, I think all the three speakers have drawn attention to this lack of internal focus. 10 years ago, I think 2002, and if I'm not mistaken, Vivian was present there, the chairman of the Securities and Exchange Board of India, G.N. Bajpai, convened a meeting of all editors dealing with financial reporting. There were 30 or more of us in a room. And he said to us that it had come to his notice that there were several cases of insider trading and market manipulation by business journalists. And SEBI had decided to come out with a code of conduct for business journalists. And he had a written text. The entire media present in the room said, we will not accept a SEBI code of conduct, but we agree that there are bad eggs or whatever, black sheep or whatever you'd like to call in the profession. We will regulate them internally. We will come out with our own code of conduct. A committee of 3 was formed. Pranay Roy, Raghav Bahl and Sunil Jain. From among us, we were all sitting around a table. That was given the responsibility of drafting an internal code of conduct that would be universally accepted by the entire financial media. I am not aware till today whether there is in fact such a universally accepted code of conduct for business journalists. But there is no stated professional code of conduct. And there is no penalty for insider trading or for market manipulation. Even today we know people who indulge in insider trading and market manipulation in the financial media. Editorial leadership is the first call of a court of appeal. The number of editors in this country is going down. The number of publications is going up and the number of editors is going down. How many publications in the country today have professional editors? Who do you go to? I don't want to take names, whether it's a television channel or this newspaper. Who do you go to with a complaint? Often the editor is the owner, who has no time for the newspaper because he's busy running the company. So there is a crisis of professionalism, of accountability in the media today. Outside of the publication or media organization, we have no professional organizations that people can approach, that professionals can approach. There is something called press council and people have already spoken about it. Till Justice Kaju was appointed, very few people even knew the existence of the press council. He has given the organization publicity by giving himself publicity. But the press council has real no teeth. I'm not aware of a single case where mistakes caused by the media, by professional journalists have actually been rectified or people punished, or people have lost a job, editors have been sacked for mistakes by the press council. Then there is something called the Editors Guild, which is essentially an organization of retired editors and want-to-be editors. Not one editor is a member of the Editors Guild, to the best of my knowledge. So, we don't have professional institutions which would enforce professional accountability. And we have created a vacuum. I think the time has come for the media to generate its own resources and create institutions that will regulate the media. Even this meeting is funded by a stiftung. In the bad old days, when the media was really under siege, like the emergency, when people used to call the IIC a CIA outfit because the Ford Foundation had initially funded it. There would have been someone from the IB, and I'm sure there will be someone from the IB here taking notes to report on this meeting, would have taken down IIC as a meeting funded by a German Stiftung with foreign journalists attacking government of India. So we can all fancy ourselves into imagining that we are under siege. But the fact is that I can't think of many countries in the world where the media is as reckless in its freedom as it is here.